Welcome back. My name is Patrick Nolan. I'm an attorney licensed in the state of Missouri. This is Pat Talks Law. Today I want to talk to you about the recent Missouri State Supreme Court decision in State v. I think it's James Bales. Again, let me also, before I get into this, preface this by saying the PTLs in the car, the windshield times, this is a lawyer just rapping, shooting from the hip. Clearly, I don't have all the documents in front of me. I'm not referring to them. If you want to go look it up, you can. And you probably should. This State v. Bales is a search and seizure case. The state police officers seized the cell phone of the defendant, allegedly pursuant to a warrant. Then they viewed the information on the cell phone. Then they got a second warrant for the information on the cell phone. Mr. Bales took issue with this. He filed a motion to suppress. After the hearing on the motion to suppress, the court found that the original search warrant was facially deficient, so as no officer could reasonably rely upon it, and suppressed the evidence against Mr. Bales. The state appealed. The case went up to the Missouri State Supreme Court, who issued their decision, and here we are. General facts of the case. This was a child abuse case. Mr. Bales' child had suffered an injury. They investigated it. Mr. Bales had a videotape of the child doing a face plant, on hands and knees, rocking, and then just going down on his face. And he showed that video to law enforcement. Mr. Bales believes that video cleared him of the offense. Law enforcement believes that video convicted him of the offense. Law enforcement sought a search warrant for a black Samsung Galaxy cell phone in a black case located at Mr. Bales' address. And I have to stop. Road construction season. So, Mr. Bales then went down to the police station, visited with the detective, and while he was there, his cell phone was seized, allegedly pursuant to the warrant. In the inventory and property list that the detective turned out, identified that the cell phone was seized as a result of the execution of the warrant on the residence, which is not what happened or how this occurred. That was followed up with the at suppression hearing, that admission was made. The court held that the search warrant was not particularized to a satisfactory degree, as there was nothing to distinguish this black Samsung Galaxy cell phone in a black case from any other black Samsung Galaxy cell phone in a black case. They didn't include the phone number in the warrant, the IME, or something that would distinguish that phone. So, the court struck that down, tossed it out. The state appealed. On appeal, the Supreme Court looked at both of the issues. First, the cell phone search warrant for the seizure, and they upheld that it was not individually particularized to that cell phone, and that the cell phone was not seized during the execution of the warrant at that location. Ergo, there's no independent verification that is the cell phone that the warrant was for. It was tossed. Now, the Supreme Court stopped there because under the fruit of the poisonous tree doctrine, that ends all the further constraints. However, the trial court, the circuit court in Pulaski County, had also reached the conclusion that by searching the contents of the phone prior to getting the second search warrant, that is a constitutional violation, And under that fruit of the poisonous tree doctrine as well, that's also out for a second reason. The Supreme Court did not need to reach that point, because in reaching the first point, it was dispositive of the issue. So the Supreme Court addressed the first point, didn't address the second point, but in dicta said, yeah, that's pretty much right. That is the Bales case in the synopsis. What is it? Well, before I go any further, hey, I'm getting hammered on the logarithm. Hit the like, hit subscribe, drop a comment. If you like some of the other law videos, things that are not medical marijuana, let me know. Drop a comment, because I'd like to do more of these. Frankly, they're more interested in griping at the state's medical marijuana all the time. And you're never going to get growing advice from me, man. I literally can't grow a weed. Think about that. So, in this situation, the things that were done wrong. First, Mr. Bales should never have talked to the police. I say this all the time. It's critical. Don't talk to the police. He thought this video cleared him. The police officer thought that video convicted him. Anything you say can and will be used against you. You might think that what you're saying is evidence that clears you. The officer is going to use it to convict you. Shut the hell up. Okay? Go talk to an attorney. If your attorney says, yeah, go ahead and talk to the police after he hears about your case, go get a different attorney and shut the hell up. Don't talk to the police. If there's anything that needs to be said to the police or the prosecutor, your attorney will do it. Because they can do it in a way that isn't going to freaking convict you. Don't do it. So, setting that aside, okay, you talk to the police, he shouldn't have. He showed him a video, he shouldn't have. But this worked out for him in a rather unique and unusual manner. Okay? What Mr. Bales needed to know is that he got lucky. The state attempted to argue good faith on part of the officers, and good faith is always a risk, because the court can find good faith. In this case, the court found that the search warrant was facially defective and that no officer could reasonably rely upon it. It is extremely rare that a court finds its own search warrant is facially defective. Okay? That doesn't happen a lot. That said, search and seizure is key. Your attorney's got to look at this. When we get into a search warrant and a search warrant case, we look at the affidavit. Okay? What is alleged in the affidavit? Is it reliable? Are they relying on a confidential informant? If the confidential informant is being relied upon, what are they giving as far as indices of reliability for that informant? They've never worked with him before? That's not an indicator of reliability. They have worked with him numerous times in the past, and he's always been accurate. That's an indicator of reliability. Okay? If the confidential informant says that, Bob Jones, no relation to any Bob Jones, just a name I pulled out of my ass, but Bob Jones is receiving a shipment of methamphetamine at 123 Main Street at 12 noon on Wednesday. Okay? Is that statement enough to get a search warrant and kick the door in? Well, who's the informant? Is the informant Bob Jones' wife? If so, it might be. Is the informant a former co-conspirator who is taking steps to get out? They're saying, look, they talked to me about getting involved in this, and I spoke to them a little bit, but dude, I got nothing to do with this. This is what they're doing. Well, that might be enough. Do they have any other statements that the informant gave them that they can verify? That Bob Jones receives this shipment every month at noon. and they can track it through the FedEx records, or the delivery guy has somebody scout the neighborhood at 10 a.m. to make sure there are no cops watching. If so, that might be enough. These are the things that go into this. I'm really sorry about the video quality. I'm in my wife's car, which means I had to transfer the cell phone mount. It's in a different location, and it's getting just a hint of sun occasionally on the camera, so it washes out. Sorry about that. So, the reliability of the information that they got in the warrant is an important part of it. Okay? Is the search warrant narrowly tailored to the evidence they're looking for? And is that evidence labeled with a particularity, the place labeled with particularity? The address, the color of the building, the number of doors and windows. These are things that go into that. What is the item that they're looking for? All too frequently you will see a search warrant that says any contraband. That's not a search warrant. That's a general warrant, which is prohibited by law. Yes, a general warrant, no good. Now, once again, you got to fight that with the court that issued it. So, your mileage may vary. At the end of the day, what happens is you have to argue, and there's some case law from a couple of years ago, that the check boxes on search warrants are presumptively invalid because they're not particularized. I'm in the process of fighting one of these right now, and we'll see what happens. It comes down to, are all the criteria for a search warrant met? And the attorney's got to sit down and review each warrant, go back, look at the case law that's relevant to the things that they see in that warrant. The affidavit, the application, and then challenge the facts of that warrant specifically. And it can be done, man. It's not a complicated thing. It surely can be done. The next question is, did they execute the search warrant properly? Did they document it? Did they, what they collected? Okay? For like this cell phone in this case, they got in and they searched the cell phone. Well, seizing a cell phone is different than searching a cell phone. The search warrant, the first one allowed them to seize it. They needed a second warrant to search it. When they searched the phone without getting a second warrant, they violated this defendant's constitutional rights. That's a problem. So that's like, there was an entire line of argument that a search warrant for blood, you get a search warrant to seize the blood in a DWI. But then do you need a second warrant to actually process that blood to test it? And there's a reasonable argument that you do. However, the court has not found that was a reasonable argument. Sorry. So, these are things that we just have to deal with on an individual basis, and it's why you need a lawyer. If you're facing criminal charges, get a lawyer. Please. Now, that's all I have for today. Please hit like, subscribe, drop a comment. YouTube will bury the videos if you don't hit like and you don't drop a comment. So please help me out. I threw some ads on this, but we're not making anything. And I'd appreciate it. Have a good day. We'll be talking again soon.